Welcome to the EPG Pathshala. My name is Purva Raghunath Karthik. I am pursuing PhD from the Center of International Legal Studies, Jawaharlal Nehru University, New Delhi. Here we are going to discuss a module of caste discrimination in the international human rights context. In this module, we are going to discuss how practice of caste discrimination amounts to violation of international human rights. Moreover, the focus will shift towards failure of well-crafted national laws which eventually invited the attention of international community. Let us begin with the introduction. As we know, the most important purpose of the United Nations is the protection and promotion of human rights. The adoption of Universal Declaration of Human Rights in 1948 by the United Nations led to the codification and promotion of human rights with the common standard of achievement for all people and nations. Subsequently, the concept of human rights expanded from first generation of political and civil rights to the second generation of economic, social and cultural rights to the third generation of right to development and rights of the indigenous people. In all these transitions, principle of non-discrimination played a significant role. As a result, various international human rights laws prohibits different forms of discrimination. In India, the caste discrimination exists since time immemorial. It became inherent part of our tradition. People were separated on the basis of their caste, which was based on four varnas, that is Brahmins, Kshatriyas, Vaishyas, Shudras, and later on the fifth varna, untouchables, was added, where untouchables were placed at the bottom of this system and who were outcast. The caste was attached with them prior to their birth. Thereafter, the attached caste determines the future of the such persons in all spheres of life, ranging from social status to economic, educational, cultural, occupational status. Caste discrimination in the given social structure ensured certain benefits to higher caste in the hierarchical nature as compared to lower caste. Moreover, members of the lower caste, particularly Shudras and untouchables, were assigned humiliating work such as manual scavenging, leather work, sweeping, etc. They were traditionally prohibited from engaging in agriculture. In addition, they were denied access to water, education, land, market and employment. Moreover, the concept of pollution was also attached with untouchables. The untouchables was equated with the polluter, a sign of impurity. Its touch or shadow would pollute upper caste. While explaining the practice of caste discrimination, Professor Thorath mentioned that the main attributes of traditional caste system are social, physical isolation and exclusion through endogamy, residential segregation or separation, social distance through the religious notion of pollution and untouchability, restrictions on property rights and occupation, lack of access to civil and religious right and maintenance of system through social ostracism and penalties with support from religious ideology. Time and again, social reformers from Buddha to Ambedkar challenged the age-old practice of caste system and strongly demanded the protection of human rights of Shudras and untouchables. After independence, the Constitution of India prohibited caste discrimination under Article 14, 15 and 16. Further, It recognized the members of the Shudras and untouchables as the scheduled caste, scheduled tribes and other backward classes. It guaranteed equal status to every citizen, including scheduled castes, scheduled tribes and OBCs. The Constitution of India abolished untouchability, and the state is under constitutional obligation to protect its citizens from all forms of discrimination by enacting protective laws. It owed to establish egalitarian society with equal status and equal opportunities to all, irrespective of any kind of discrimination. It ensured justice, equality and fraternity to all for the first time in the history of India. The legal system has responded to discrimination with preventive and curative approaches with an objective to attain a social justice and equality. As a result, in 1989, the Scheduled Caste and Scheduled Tribes Prevention and Atrocity Act was enacted to prevent and punish states and private actors committing atrocities. Similarly, various other legislative enactments such as Protection of Civil Rights Act, Manual Scavenging and Construction of Dry Latrine Act, Bonded Labor Abolition System, etc. were passed. However, except certain benefits in education and employment, the members of scheduled caste and scheduled tribe witnesses atrocities. Dalits are often victims of police abuses and discrimination by executive and judiciary. Many laws lack credibility as they are not effectively implemented. Despite all these enactments, the Indian government failed to generate political will to prohibit caste discrimination. The report on prevention of atrocities against scheduled caste and scheduled tribes submitted by K.B. Saxena to the NHRC in 2004, the main object of the report was to examine the implementation of laws that prohibit atrocities against scheduled caste and scheduled tribes. The report shows that the organ of the state machinery are responsible for the failure of implementation of laws. This failure and unwillingness to implement the laws in an effective manner result in a gross violation of human rights and invites attention of international community. Now, let us move towards the international human rights laws and reports of human rights bodies, as these international treaties creates legal obligation on state parties, and to monitor the implementation of these treaties, human rights treaty bodies were formed as given in the chart. To exercise these international human rights laws on prohibition of caste discrimination, various efforts were made. For example, once Dr. B.R. Ambedkar mentioned that he had prepared a report on the conditions of the scheduled caste for the submission to the United Nations. However, the report was not submitted as opportunity was given to the Constitution Assembly and future Parliament to deal with the matter. The Universal Declaration of Human Rights recognized the various grounds of discrimination derogatory to the practice of human rights. It includes race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. A year after independence, India adopted UDHR. However, no reference was made by India to include caste as a form of discrimination under Article 2 of the UDHR. Further, in the 100th meeting of the Third Committee of General Assembly, India proposed to insert word caste as a form of discrimination under Article 2 of the UDHR, objecting to the inclusion of birth. However, the Indian delegation found the term or the status and social origin sufficiently broad to include caste, and therefore did not insist upon its proposal. Thereafter, the International Covenant on Civil and Political Rights prescribes equal protection of law to all people without any discrimination. Article 26 of the Covenant guarantees all persons are equal before the law and are entitled without any discrimination to equal protection of law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protections against discrimination on any ground such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. In 1997, the Human Rights Committee in its concluding observation found that India was violating its obligation under the International Covenant on Civil and Political Rights. As a member of scheduled caste and scheduled tribes, faced several social discrimination on the basis of caste. The committee observed that despite measures taken by the government, members of the scheduled caste and scheduled tribes as well as the so called backward classes and ethnic and national minorities continue to endure severe social discrimination and to suffer disproportionately from many violences of their rights under the covenant. Inter alia, intercaste violence, bonded labor and discrimination of all kinds. It regrets that the de facto perpetuation of caste system entrench social differences and contributes to these violations. While the committee notes that the efforts made by the state party to eradicate caste discrimination, it recommends that further measures be adopted, including education programs at national and state level to combat all forms of discrimination against these vulnerable groups in accordance with Article 2 of the Covenant. The grounds of discrimination under the International Covenant on Economic, Social and Cultural Rights are identical to the International Covenant on Civil and Political Rights. Moreover, the principle of non-discrimination is the basis of labor standards established by International Labour Organization. The ILO Convention 111 on the Discrimination, Employment and Occupation of 1958 prohibits distinction, exclusion and preference on the basis of race, color, sex, religion, political opinion, national extraction or social origin. While elaborating these 7 grounds under the Declaration of Fundamental Principles and Rights at Work, it covered caste based discrimination under the category of social origin. The declaration explains social origin as a discrimination towards certain individuals because of their social class, socio-occupational category or caste. In some context, the social origin can be influence the professional future of the subject because he or she is denied access to certain job or he or she only assigned certain activities. The object of International Convention on the Elimination of All Forms of Discrimination against Women is to promote equality of right of man and woman. For full enjoyment of their rights, it emphasizes on eradication of apartheid, all forms of racism, racial discrimination, colonization, colonialism, non-colonialism, aggression, foreign occupation and domination and interference in the internal affairs of the state. Article 1 of the Convention prohibits sex discrimination as follows. For the purpose of the present convention, the term discrimination against women shall mean any distinction, exclusion or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and a fundamental freedoms in the political, economic, social, cultural, civil or any other field. As per the above article, women are discriminated on the basis of sex only. Apart from the sex, caste is a major factor contributing in violence against Dalit women. Dalit women are not only discriminated on the grounds of sex, but also on the basis of caste. As author Gita observed that women are seen as a gateway to the caste system. Their bodies are the sites of caste honor, and the higher the status of caste, the more securely must the female persons of the caste be graded and protection from the roving gaze of lower caste men. The lower the status of caste, the bodies of women of that caste are literally freely available for possession, abduction, sexual assault by men of higher caste. A caste strives to maintain its integrity by policing females sexually and by encouraging women to hold their chastity dear, not only for their sake, but for the sake of caste honor as well. Dalits, by virtue of who they are considered to be, are easily punished by dishonoring their women. The situation of scheduled caste and scheduled tribes women is most vulnerable due to caste system. In order to improve the condition of scheduled caste and scheduled tribes women, the attempt was made in 2000, where for the first time the Committee on the Elimination of Discrimination against Women recognized violence against women on the basis of caste. India is a signatory to the convention and submitted its first report to the committee in the year of 2000. The committee, in its concluding observation of the India's report, raised the issue of discrimination faced by the Dalit women. The committee mentioned that because of the customary practices such as dowry, sati and devdasi system, there is a high incidences of gender based violence against women. Discrimination against women who belong to particular caste or ethnic or religious group also manifest extreme forms of physical and sexual violence and harassment. The committee concerned with the continuing discrimination, including violence suffered by women of the Dalit community. Despite the passage of Scheduled Caste and Scheduled Tribes Prevention of Atrocity Act, the committee urged the government to enforce laws preventing discrimination against Dalit women and prohibit Devdasi system. It also recommended the government to introduce affirmative actions programs in the areas concerning education, employment and health. This was mainly to provide life chances to Dalit women and girls and create an environment conducive to their progress. It noted that widespread poverty, social practice such as caste system and son preference as reflected in high incidences of violence against women. Further, significant gender disparities and adverse sex ratio present major obstacle to the implementation of the convention. The Convention on Rights of the Child guarantees certain rights with the special care to children. The Committee on the Rights of the Child, in its concluding observation to the report submitted by the India in 2000, recognized caste system as an obstacle to combat discrimination. Article 2 of the Convention defines discrimination as state parties shall respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination of any kind, irrespective of the child's or his or her parents or legal guardians, race, color, sex, language, religion, political or other opinion, national, ethnic or social origin, property, disability, birth or other status. State parties shall take all appropriate measures to ensure that child is protected against all forms of discrimination or punishment on the basis of status, activities, expressed opinion or belief of the child's parents, legal guardian or family members. In the light of Article 2 of the Convention, express concern over the striking disparities in terms of access to education and opportunities between children belonging to different castes. It also expressed the concern as to existence of caste based discrimination and discrimination against tribal groups despite the practice has been prohibited by laws. Further, the Commission special rapporteur on sale of children, child prostitution and pornography found that children of untouchables are most often victimized in child labor situation. The committee recommended that the state party should take appropriate steps which includes abolition of untouchability, prevention of caste and tribe motivated abuses, and prosecution of state and private actors responsible for such practices or abuses. Moreover, in compliance with Article 46 of the Constitution of India, the state party is encouraged to implement inter alia affirmative measures to achieve and protect these groups. The committee recommended that there should be full implementation of Scheduled Caste and Scheduled Tribes Prevention and of Atrocities Act 1989. The state shall promote with special care the educational and economic interests of the weaker section of the people and in particular of the scheduled caste and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. The state party is encouraged to implement inter alia affirmative measures to advance and protect these groups. The committee recommended that there should be full implementation of Scheduled Caste and Scheduled Tribes Prevention of Atrocity Act 1989, Employment of Manual Scavenging and Construction of Dry Latrine Act 1993. The committee encouraged the state party to continue its efforts to carry out comprehensive public education campaigns to prevent and combat caste discrimination. In its concluding observation to the second periodic report of India, the committee expressed the concern at the wide disparity in the level of employment of the rights in the convention by girls, children living in the certain states, rural areas and slums, and children belonging to certain castes and tribes and indigenous groups. It recommended concentrated efforts for address social inequalities by reviewing and receiving policies, including increasing budgetary allocation for programs targeting the most vulnerable groups. All the above respective human rights treaty bodies report all the above respective human rights treaty body reports recognized caste as a form of discrimination by one or another term. After recognition, it recommended that Indian government should take preventive measures. Despite all the evidences and occasional recognition of caste-based discrimination by the United Nations human rights treaty bodies, neither Universal Declaration on Human Rights nor the two covenants and other convention has mentioned caste as a form of discrimination in express terms. The international human rights treaties prohibits all forms of discrimination, but the word caste does not appear in any international human rights treaties. However, caste as a form of discrimination came into picture after 1996. The Committee on the Elimination of Racial Discrimination in 1996 made first attempt to favor such recognition. The next section deals with the inclusion of caste as a form of discrimination under descent based discrimination. The International Convention on the Elimination of All Forms of Racial Discrimination was adopted in 1965 to eliminate racial discrimination throughout the world. At the time of drafting the convention, special attention was given to apartheid, but it also covers other forms of discrimination. The scope of racial discrimination has also been expanded through interpretation. The term racial discrimination shall mean any distinction, exclusion, restriction or preference based on race, color, descent or national or ethnic origin, which has the purpose of effect of nullifying or impairing the recognition, enjoyment or exercise on an equal footing of human rights and the fundamental freedoms in the political, economic, social, cultural or any other field of public life. Article 2 of the convention added that states shall take all necessary measures for development, protection of all human rights and fundamental freedoms of certain racial groups and individuals belonging to them. India is a signatory to the convention and obliged to comply it. Indian government opposed to the discussion and inclusion of caste discrimination under the rubric of convention as it is not a form of racial discrimination. As per the above definition, racial discrimination is based on race, color, descent or national or ethnic origin. On this basis, Indian government argues that discrimination on the basis of caste is not covered under the convention. In 2002, the Committee on the Elimination of Racial Discrimination issued a General Recommendation 29 where it interpreted the term descent. It set out certain norms including descent based discrimination in relation to caste as those descent based communities under their jurisdiction who suffer from discrimination especially on the basis of caste and analogous system of inherited status and whose existence may be recognized on the basis of various factors including some or all of the following: inability or restricted ability to alter inherited status, socially enforced restriction on a marriage outside the community, private and public segregation including in housing and education, access to public space, place of worship, and public sources of food and water, limitation of freedom to renounce inherited occupation or degrading or hazardous work, subjection to debt, bondage, subjection to dehumanizing discourse, discourses referring to pollution or untouchability, and generalized lack of respect for their human dignity and equality. Further, taking note of India's position, CERT maintained its position in General Recommendation 29 and stated that discrimination based on a descent includes discrimination against members of the communities based on forms of social stratification such as caste and analogous system of inherited status, which nullify or impair their legal enjoyment of human rights. Therefore, the committee reaffirmed that discrimination based on caste is fully covered under Article 1 of the Convention, mainly at a World Conference against Racism, Racial Discrimination, Xenophobia and Related Intolerance in 2001. Various Dalit NGOs raised the issue of caste discrimination. In this discussion, arguments were received from both the sides, one in the support of inclusion of caste in international conventions and another opposed to it. The government argues that there already existed national mechanisms to overcome caste discrimination, hence felt no to mention a caste at an international level. On the other hand, the NGOs countered that these national laws and mechanisms have completely failed to overcome caste discrimination, as the atrocities are on the rise. Therefore, concern at an international level is must. No fruitful results were yielded yet, and the debate still continues. To summarize, this module has hopefully offered you a brief understanding of caste discrimination. Moreover, it has discussed various international human rights laws prohibiting caste discrimination, without expressly including caste as a form of discrimination. Finally, to conclude with the Dr. B.R. Ambedkar's anticipation that the Indian migrants will carry the caste system to the other regions of the earth and it would become a problem of the world seems true. It need to be prohibited through national as well as international human rights laws. Thank you.